Good afternoon. Today we're going to discuss gender equity law and how it affects sport and recreation. So in this chapter, we're going to learn about different types of federal general gender equity laws. We'll look at Title IX and certainly how it's grown and a lot of the recent changes over the past couple of years in terms of sexual assault notifications. We're going to get into sexual harassment, how it's regulated in sport and other organizational situations, and look at employment discrimination law. So discrimination, we're going to look at discrimination here. It's going to be presented in terms of gender, but overall discrimination can be a part of two different types of legal theories. One is this disparate treatment. Disparate treatment means a person is being discriminated against directly. The discrimination is against this person. In order to create a prima facie case, and prima facie case means it is a claim on its face that discrimination has occurred. The first element to it is the person making the claim must be a part of a protected class. The discrimination needs to be a part of race, color, national origin, religion, or gender. So a person needs to be a part of a protected class first. Second, they had to have applied for a position and was qualified. Step 3, they were rejected. And that could be applying for a brand new job or a promotion or for their existing job right now. And then fourth, the position has been filled by a person who's not in a protected class or the position remains open. So on a prima facie case, in order to bring a claim of discrimination, the first element has to be a member of a protected class, either race, color, religion, or gender, or national origin. You applied for a position, was qualified for that position, you were rejected, and the position was filled by a person not in a protected class at all, or it remained open. That was disparate treatment. Now, after the prima facie case made by the plaintiff, it then goes through a burden shifting analysis. The defendant has now the burden of production to support its own defense. And the defense is SLNDR, some legitimate non-discriminatory reason. That the person was not hired or the person was rejected for some legitimate non-discriminatory reason. It could be a bona fide occupational qualification, the other person had more experience. There has to be some reason in there for that defense that is non-discriminatory. So it starts off with the plaintiff to establish the prima facie case. It goes to the defendant to produce its some legitimate non-discriminatory reason. Then it goes back to the plaintiff, who has the burden of proof now to establish that that defense is pretext, that defense isn't true. And it must be shown by preponderance of the evidence that the defendant is going to come up with some legitimate non-discriminatory reason. But then the plaintiff has to show that this is, either based, the other person didn't have more experience, the other person, it wasn't a bona fide occupational qualification. Whatever that defense was, the plaintiff has the burden through a preponderance of the evidence to say that it was not true. That was disparate treatment. Disparate impact is when a person is indirectly discriminated against because criteria that's supposed to affect everyone neutrally actually affects a class of persons. For instance, in the early 70s, there was a lot of civil tests for policemen and fire departments where they would have to do some sort of strength test. And the strength tests were set where they were awfully difficult. On its face, it made sense because it affects everyone neutrally. Everyone wanting to be a fireman has to carry a 100-pound pack up 3 flights of stairs. However, it affects women more often because of the strength requirements. Now, if that requirement was true, and I think we all agree that firemen do have to carry heavy loads up flights of steps. The question is 100 pounds the correct number? Or is 50 the real number? Somewhere in there, there's a number that the actual job needs to have in terms of a qualification. If it's set higher than that, it's going to affect people in a different class more often, such as females in terms of strength, perhaps. A defense in this could be a business necessity, that U.S. Marshals requiring hearing aids isn't going to work out well, or strength requirements for firefighters. It has to be a certain specific area, maybe a disparate impact where it's affecting everyone equally would be eyesight for airline pilots. We all agree that there has to be some sort of requirement that all pilots should have very good vision. Is it 20/20? Is it something above or below that? That's something that we need to address, because even though it affects everyone neutrally, it may affect a class of person in a protected class more specifically, and that would be a disparate impact. Appears as though there's a problem with this. Let me pause this and see if I can, oh, it came back. Underrepresented in terms of athletics. Women have always been and continue to be underrepresented in athletics. In 1971, before Title IX began, there were 16,000 women in college athletics. In 10 years later, we're looking at 90,000. Another 15 years, it almost doubled. We're seeing a huge growth in women's athletics. The idea of what should come first, opportunity or interest, certainly has been put off to the side. That the opportunity created by Title IX and other types of equity laws really led to this idea of participation. Title IX. What is Title IX? Title IX is actually an educational law created in 1972. The words of it: no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So we look at this idea that it's an education law, that no person on basis of gender shall be denied the full opportunity to an educational program. Simply put, the Title IX prohibits programs that receive federal funding from excluding individuals from participating in the programs or denying individuals access to benefits that the programs may provide. Title IX applies to any department in a school that receives federal funding. So if a student financial aid is federally developed, a Pell Grant or some sort of scholarship fund that's federal, that would extend throughout the entire school. The Civil Rights Restoration Act of 1987, in response to a Grove City ruling that we'll look at in a few minutes, passed this idea. We're looking across the board in our court system and our government to eliminate discriminatory practices. And this began the idea in the early 70s of an educational program. It grew into athletic program, but now Title IX is really focused on the college atmosphere as a whole and is doing a lot of educational work and prevention of sexual assault and publicity of sexual assault. Again, this idea based on gender: no person shall be denied the benefits of or be subjected to discrimination for an educational program. Certainly sexual assault is a major concern in the colleges these days, and Title IX is a great tool that universities are using to combat this horrific aspect to it. So in 1984, one of the seminal cases was Grove City versus Bell, and we will discuss that and talk about that during our discussions. In this case, in 1984, one of the biggest setbacks for women because of the Grove City College, the court found that Title IX was only applicable to parts that receive federal funding. So if a chemistry department wasn't getting any National Science Foundation money or anything from the federal government, according to this common law discussion, then that area would be excluded. Congress, in response to this, passed a law that said no, if any part of a college receives federal fund, it applies to the entire college. Title IX certainly has been really closely identified over the last 40, 50 years with the idea of the NCAA and women's athletics. In 1999, the NCAA itself is not subject to Title IX because it doesn't receive any federal funds. So the NCAA filled with individual member schools. Those member schools need to be compliant with Title IX if they receive federal funds. However, the NCAA itself, the organization in Indianapolis, does not need to be compliant to Title IX. However, as we look in some other aspects and through our constitutional law aspect, the NCAA has taken tremendous steps to try to include Title IX and other constitutional right issues as a part of their organization. And they're at the forefront of providing equitable opportunities for women. Mentioned the Civil Rights Restoration Act 1987. Congress reversed the findings in Grove City and said we really mean to say institution-wise, if anybody is receiving funds from the federal government, then the entire institution has to be subject to Title IX legislation. So in terms of regulation and enforcement of Title IX, the Department of Education Civil Rights area is the group that actually enforces Title IX, and it's grown differently over time because this was actually created by Congress in 1972, but no one really knew what to do with it. So in 1975, the Department of Education says, you know, it focuses on equal opportunity. In some of these program areas like equipment, locker room, we'll look at a couple, effective accommodation of interests and abilities and selection of sports for both genders, and equivalency of financial aid. We kind of look at these and we've redefined them over time, but we're looking at this idea of, you know, we're creating equal opportunity. In 1979, colleges were very legitimate in trying to address these issues. We may have had a lot of athletic departments still run by from a masculine dominated or male dominated area, and they don't want to give up power, don't want to give up money or resources fighting this. But in terms of a college, we're looking to get this, and a lot of colleges were saying, you know, we want to be compliant, however, we don't know what we're supposed to be doing. So in 1979, there's a policy interpretation from the Department of Education, again, to say this is how we're going to regulate it. Part 1 has to deal with financial assistance. Requires financial assistance to be allocated equally to male and female athletic participants. That there's an equality in program areas, facilities and equipments need to be equal for men and women. And there needs to be an effective accommodation interest to provide athletic opportunities. So we're looking at this idea, what is equal? How do we become equal? Does it need to be 50-50? Because certainly in the 70s, you know, women were just beginning to be a part of athletics. We looked at that one stat that says only 16,000 women were participating in athletics in 1971. So from an athletic department perspective, you're saying I need to give up half my money for only a small percentage of women. Now with interest has grown through these opportunities, it's much more even, and you can make that it's easier to see that women deserve and encourage the breakout of the financial aspects. However, in 1974, without this large category of women playing, it was a lot more difficult to establish that in terms of an athletic department point of view. So Title IX looks at the following components: equipment and supplies. Are they equal for a men's team and a women's team? Scheduling of games and practice time, travel, per diem allowances, opportunities to receive academic tutoring, opportunity to receive coaching, assignments, compensation, locker rooms, medical and training facilities, housing and dining facilities, publicity, support services, recruitments of student athletes. We look at these different program components, and it has to be equivalent for the male and female programs. Nancy Lowe from the University of Nevada, Las Vegas, and Barbara Osborne from University of North Carolina, Chapel Hill, had a great line in one of their presentations. They said, The simplest way to see if you're in compliance with Title IX, you take a male team and the equivalent female team. So you take the male basketball team and the equivalent female basketball team, and you switch everything. You switch practice times, you switch budgets, you switch travel, you switch everything from male to female. And if no one complains, if neither team complains, then you're compliant with Title IX. If you have somebody complain because they are now receiving less than they had before, then you weren't compliant in Title IX to begin with. I think that's an interesting line. Simpson versus University of Colorado talks a little bit more about how Title IX, perhaps in a sexual assault context, is appropriate. Now we're moving towards this idea of the three-prong test. After 79 and the late 80s, we looked at these three prongs to say, are we compliant or not? So prong number one, are the participation opportunities for both sexes substantially proportionate? By substantially proportionate, we do not mean equal 50-50. It means if your college campus is 60% female and 40% male, then your participation opportunities should be 60% female and 40% male. It's a safe harbor if participation of the underrepresented sex is substantially proportionate to the other sex. If so, stop here because compliance is determined. If not, keep going. So if you're 60% female on a campus and you're offering 60% participation opportunities, you are then compliant. If not, prong two, can the institution show a history and continuing practice of program expansion? This prong came into effect after the idea of being equal. A lot of colleges were saying, you know what, we now have to be compliant with Title IX. We want to be compliant with Title IX. However, we can't just change everything right now immediately. So the Department of Education said, you know what, and the Office of Civil Rights said, you know what, if you're increasing program expansion, then we'll allow that. This, however, should be a short-term effect that, you know, in a very not too distant future of practice expansion, you should reach prong number one, substantial proportionality. Prong number three, have the interests and abilities of the underrepresented sex been fully and effectively accommodated? Meaning we may not be substantially proportionate. However, according to our student body, we've met the interests of them athletically. And we'll discuss this in a little bit further detail. Cohen versus Brown University, 1993, another one of the seminal athletic cases in Title IX. In 1996, it reiterated that this idea, the three prongs, are legitimate. Substantial proportionality is an issue if there are enough athletes to sustain a team. Prong number two, school must continuously expand opportunities in response to women's interests. And number three, must effectively accommodate interests and abilities of admitted and enrolled students. Title IX allows schools to sponsor teams of an individual sex if the selection is based on athletic skill or if the sport is a contact sport. That's why we see differences between men's basketball and women's basketball. However, if females are allowed to try out for a contact sport, and we'll look at a couple cases, if a woman is allowed to try out for football, then she must be given the same opportunity to make that team and all the educational benefits and all the athletic benefits that would be a part of that team. However, there's no contact sport exemption for the school's compliance evaluation. Contact sports, even if predominantly male, are still taken into account under prong one. That's that football influence that we're still, after all this time, trying to come to grips with the fact that football has 85 different scholarships. We're looking to be compliant even with that ability at a D1 level. Mercer versus Duke University highlights this idea of a female trying out for a male sport. Cutting teams. Cutting teams is allowed under prong 1. We're talking about substantial proportionality. It doesn't necessarily mean we need to invest more money and increase female opportunities, although that is favored in the 2003 Office of Civil Rights clarification. However, we can cut men's programs in order to be compliant. The 2003 Office of Civil Rights from the Department of Education clarification said, you can cut men's sports, but we heavily favor increasing female opportunities for Title IX. It works for substantial proportionality, but it doesn't work with the overall idea that you're looking to increase female opportunity. Miami University versus Wrestling Club versus Miami University. 1997, it was 55% female students and only 47% female student athletes. The Miami University cut the wrestling club to become substantially proportionate. The men's team sued. The court dismissed the complaint because the members of the overrepresented sex, the men, don't have a claim under the 3-part test because prong 1, prong 2, and prong 3 wouldn't apply to them because they are overrepresented. Men cut from men's teams have never won a lawsuit against the school. Cutting women's teams is never allowed, in so far that women tend to be the underrepresented sex. So if women are overrepresented and their team is then cut, then the gender would flip-flop in terms of the cutting the women's teams and men's teams. However, across the board, women's teams are underrepresented. Therefore, there really aren't any cases that show women being cut to become compliant to prong 1 of Title IX. The Beedinger case versus Quinnipiac begins to discuss about cheerleading, and is that a athletic team that could be used for Title IX issues. It's a relatively new case. It's a few years old that we'll go over. So recent guidance in 2005, more clarification, especially for that third prong that said internet surveys can show interest and abilities and meet the third prong. That was the one that said the interests and abilities of the underrepresented sex are fully accommodated. Well, we can't just say that, yeah, our women on our campus don't want any more sport. You need to show proof. And part of this in 2005 said internet surveys are fine. However, non-response as a lack of interest. So you have to get female input across the board. If it doesn't, if you don't get all the responses back, it's going to be counted as a non-response, is a lack of interest. So schools must receive 85% response rate in order to proceed. A school can use a survey to be in compliance with the third test unless enough female students at the school have enough interest in a sport to sustain it, if there's suspicion of ability to play the sport, and if they likely will find other teams in the school's regions with which to compete. So if that happens, it's hard to establish that your school isn't fully accommodating the interests and abilities of a female athletic team. If you're not in compliant, you certainly can grow and add teams. Sorry about that. Apparently the meeting and recording is not linking up like I would hope that it would. So just to continue, Ollier versus Sweetwater looks at Title IX in a high school setting because this isn't solely a college issue. It's any educational funding. So it does impact high school. Equity in Athletics Disclosure Act 1998 requires all universities to receive federal student aid and have athletic programs to disclose information, financial aid, revenues, and other information. This information is available to the public, so all of this Title IX information is available to the public. Wanted to also add into the California Code, the School Success and Opportunity Act, again, a gender, but this is more a transgender issue. California passed a law in 2014 that creates equal opportunity for transgendered athletes. And there's a lot of focus on transgender athletes, certainly right now, and as we're moving forward and we're looking at that category of person and those rights to be addressed both in legislation as well as common law. Second part of this discussion of gender equity, want to get into employment discrimination. Certainly the participation gains that we look at in female athletes certainly hasn't been mirrored by women in college athletics, certainly at a coaching level. In 1992, 90% of the head coaches of women's teams were women. In response to Title IX, now in 2008, that number was under 43% and going down. It's very common now to find men coaching women's teams, not as common as women coaching med teams. Certainly as a head coach, it's very few. So we're looking at this idea of employment discrimination, maybe more culturally in terms of the NCAA and other types of areas, but certainly we want to look at this in terms of employment discrimination, not just from a coaching aspect, but across the board and relevant to all of our students. Title VII of the Civil Rights Act prohibits discrimination against any employee on the basis of sex and compensation, other benefits associated with employment. Here, the plaintiff merely has to show some negative job action. For example, termination that was taken on the basis of the employee's sex. So this ties back with this idea of discrimination that we were looking at the very beginning with this idea of the burden shifting analysis. In sexual harassment, there is two different types of sexual harassment. One is the quid pro quo, which is this for that. This is the situation where employment benefits are granted or denied because of a person's submission to sexual demands. This is the infamous Hollywood casting couch. You do this sexual favor for me and I will promote you, or I will hire you, or I will give you some sort of economic benefit. If you do not, then I'm going to harm you. Second area we want to look at is this idea of hostile work environment. And a hostile work environment is conduct unreasonably interferes with work performance. It can lead to either one of these actually could lead to constructive discharge. Constructive discharge is where the job is so intolerable that the person quits. I'm not firing a person because of this. I'm not bringing a negative job action towards them. However, the job was so intolerable that they quit. So we're getting rid of that little loophole of what you fired them or didn't fire them. Doesn't matter in sexual harassment. Constructive discharge would apply. For a hostile work environment, we look at a couple of different areas in terms of this claim. First, we look at the totality of the circumstance. What happened? Was it one gesture? Was it one comment? Was it one joke? Or was it a whole series of things? It could be one thing. It could be something extremely serious in sexual harassment of a hostile work environment. Or it could be a series of smaller things. An inappropriate calendar on someone's work desk, or something, a comment in public about somebody's body would certainly fit into a hostile work environment that unreasonably interferes with their performance. So we look at the totality of the circumstance. Then we do an objective test. Whether a reasonable person in the same circumstance would find that conduct hostile, abusive, or intimidating. So we look at this more from a objective idea. Is this really hostile, or was the person being oversensitive, or were their values different than what a reasonable person would expect? And then we look at it from a subjective test. Did this plaintiff themselves find it hostile, abusive, or intimidating? So we look at the totality of it, and then we apply an objective test as well as a subjective test. In terms of looking for employer liability, the employer is liable for harassment by coworkers if the employer knew or should have known of the misconduct, unless it shows that it took immediate and appropriate corrective action, whether that's training, providing multiple complaint methods, and appropriate punishment for conduct. So here it looks like that the default is the employer will be liable for harassment that's held by their coworkers. So an employer knew or should have known. So in order to get that step, you need to prevent it. Exercise reasonable care to prevent. So training needs to be a part of everyone's, and not just as a new employee, not the binder that you get, but maybe a yearly discussion of looking at different areas. Certainly in a sport or a recreational or a physical therapist aspect, you're coming into contact with people of the opposite gender quite frequently, and in often cases in different stages of undress. So you need to talk about what is appropriate and what isn't appropriate. You need to provide multiple complaint methods, meaning if it's your employer, if it's your direct supervisor that's making these actions towards you, do you have another person to complain to? Someone in HR, a president, a vice president. You need multiple areas because if the person above you is making the action towards you, and that's the only place I can complain about, it's not going to be corrected. And promptly correct the harassment, bringing appropriate punishment for the conduct. If it's a calendar or an inappropriate joke, are you bringing the person, talking to them, maybe putting something in their file, telling them that someone's made this complaint and saying it has to change now? All the way up to maybe termination if it's egregious or if it continues. And then for the employer not to have liability attached to them, they need to prove that the employee unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer. So the default here is that the employer must have programs in place to prevent and to punish this type of behavior. And we'll look at Bowman versus Shawnee State University. Interesting here because the gender issue of sexual harassment is switched between the male and female. Equal Pay Act prevents discrimination in wages between employees on the basis of sex for equal work on jobs that require equal skill, effort, and responsibility under similar working conditions. In other words, if two jobs do not have to require the identical skill, effort, and responsibility, instead the jobs must be substantially equal, except for the fact one person's paid more, even though he performs what is basically the same job. So again, we're getting rid of that loophole that these two people really, jobs are different. We're going to look into it. Are they really different? If the jobs are basically the same, according to the Equal Pay Act, the compensation between the male and female must be equal. And we'll look at Stanley, a female basketball coach against the University of Southern California in the early 90s to illustrate this discussion. So we look at statutory requirements of Title IX and the Equal Pay Act, and certainly as we look at Title VII, Title IX, the Equal Pay Act, as we look at this discrimination in terms of a gender equity, we can compare and contrast them. Title VII prohibits discrimination against any employee on the basis of sex and compensation and other benefits associated with employment. The requirement is that the plaintiff has to show some negative job action and was taken on the basis of employee sex. Equal pay prohibits discrimination in wages between employees on the basis of sex for equal skill, effort, and responsibility, and they must show that there's equal work is substantially equal and the payment is different. We can also look at the beginning. We discussed discrimination based on that burden shifting analysis. So there's a number of different gender equity laws that apply in an employment category as well as an athletic area in order to create a more equitable area for both genders to work in and to be a part of.